we'll get straight into it then and look at the doctrine of mistake. The first thing to be said about mistake is setting a contract aside on the basis of a mistake, that one or both parties have made a mistake, is a very limited doctrine. Although it's slightly complex in places, it doesn't apply to that many contracts. The mistake has to be a fundamental mistake, and the courts are very reluctant to set a contract aside on the basis of a mistake. So bear in mind that although there are a number of cases on this, and it's one of the longer chapters in the course, it's longer more because the cases are complicated rather than because the effect of the doctrine is very wide and very broad. The first thing to say about mistakes is that no matter which of the three categories of mistakes that they fall into, when we look at those categories shortly, a simple mistake isn't going to be sufficient for there to be for you to be able to set a contract aside on the basis of mistake. It has to be an operative mistake, and it has to be a mistake of a fundamental nature. The next thing to say is that when we talk about mistakes, we're talking about mistakes of fact and not of law. So if you tried to make a claim on saying that you had misunderstood the law in the area, you won't really get very far with that, because it's assumed that we all know the law. So if you tried to say, oh, I made a mistake in law, I didn't think that was consideration, that'll be your tough luck. It's always questions of fact that form the basis of mistake. This is another part of the course where there is a conflict between equity and common law. And this is one area in which we see it. The courts of equity say that if it's a mistake of law in private law, such as the making of a will, then the courts can intervene. In Ireland, this idea of a mistake of fact and mistake of law is still of fundamental importance, but in the English case of Kleinworth Benson, this distinction was abolished. Now, Kleinworth Benson hasn't been brought into Irish law, so the distinction hasn't been abolished in Ireland. The general rule is that it has to be a fundamental mistake of fact. If it's a mistake of law, then that doesn't count. If it's this niche area of a private law matter, such as a will or some probate matter, equity might intervene, but the general rule is that if it's a mistake of law, that's not going to be enough to set aside the contract. It has to be a mistake of fact. The leading English textbook on contract law, Cheshire, Fifoot and Frumston, have looked at the cases on mistake and put in place three different categories of mistake. The first one is called common mistake, and that is where both parties make the same mistake. The phrase we use to describe this is that there was no meeting of minds. There was a meeting of minds. Both parties thought that they were engaged in a contract, but they made the same mistake. The contract became impossible to enforce. For example, the classic example, and we'll see some real cases of this, is where one party agrees to sell an item and the other party agrees to buy it. They both think that item exists, but in fact that item no longer exists. So they've entered into a contract that they both think is an operative contract, but they've both made the same mistake about the existence of an item. Because the item doesn't exist, the contract can't be performed. It's a common mistake. The other type of mistake is a mutual mistake, and that's where both parties make a different mistake. So party A makes one mistake, party B makes a second mistake. In common mistake and the third one, unilateral mistake, it's arguable that a contract was never formed because there was never a meeting of minds. There was no consensus ad idem. So in order for there to be a contract, you have to have a meeting of minds. You have to have a consensus ad idem. You have to agree with your contractual party what you're doing. In the case of a common mistake, you've agreed, it's just you've both made the same mistake. In the case of a mutual mistake, you've never actually agreed anything because you're both making different mistakes and you're talking across purposes. So the example in the book at paragraph 1207 is that X thinks he's selling a Ford Fiesta, whereas Y thinks he's buying a Ferrari. So they've both made a different mistake, and so there's no meeting of minds in that particular instance. The third category, that of unilateral mistake, generally involves some form of fraud. It's not always involving fraud, but generally it involves fraud. That's where one party, the innocent party, makes a mistake, which the other party either knows or should have known was a mistake. So the classic example is where a confidence trickster or a fraudster turns up in a shop, pretends to be somebody else, and gives a dodgy check. So the unilateral mistake there is the shopkeeper, the salesperson, thought the person was a celebrity. They generally, in the cases that we look at the end of this chapter, they generally tend to be impersonating celebrities. They thought the person was a celebrity, and on the basis of that, took their check at face value. So the unilateral mistake there was that the person was mistaken as to the identity. The fraudster knew the person was mistaken, and we have a unilateral mistake. It can be possible that you can have innocent unilateral mistakes where somebody ought to have known that the item they were selling was incorrect. And the example in your book there is X thinks he's buying Stephen Gerrard's European Championship winning jersey, and instead he's buying a cheap imitation. It should be pretty obvious to Y which is which. Y should know from where he bought it and from the type of jersey whether it's a cheap imitation or whether it's actually the championship winning jersey, and therefore you have a unilateral mistake. So in categories 2 and 3, it's important to state that there was no true agreement between the parties. So looking at the first of those, and also the longest of those, we look at the category of common mistake. There are generally two types of mistake. The first is to the existence of the subject matter. That's the most straightforward one. X agrees to sell something, Y agrees to buy it. Unbeknownst to both of them, the subject matter of the contract either never existed or no longer exists. More difficult for the courts, and more difficult therefore for students, is the concept of a fundamental underlying assumption of the contract. So we'll get to what a fundamental underlying assumption of the contract is shortly, but these are the two categories of common mistake. Looking at the first one then, the existence of the subject matter, this makes the contract unenforceable. The classic example is Couturier versus Hastings. And in Couturier versus Hastings, there was a contract for the sale and therefore the purchase of a cargo of corn. So the cargo of corn was being shipped to London, and while it was being shipped to London,